We have some breaking news to tell you about from the United States Supreme Court. Moments ago, in a 7-2 decision, the justices blocked the Trump administration from deporting a group of Venezuelan migrants under the Alien Enemies Act. It is a complicated ruling, with the court asking a lower court to make some big decisions, but it is nonetheless a legal setback for the Trump administration, who wants to use the Alien Enemies Act to deport more migrants without standard due process. Joining us to help us understand this breaking news is MSNBC legal correspondent Lisa Rubin. Charlie is with us as well.
Nicole, I should always know better than to put my hair in a ponytail on a Friday night, because that's just asking for the Supreme Court to come to us. This decision, you mentioned due process, this decision is the court saying again that people who are immigrants, even if they are undocumented immigrants, even if they are alleged members of a Venezuelan gang, are entitled to that due process. The court is refusing here to say exactly how much notice somebody who is an alleged member of Tren de Aragua is entitled to. But what they are saying is, we're going to continue our prior order that prevents the administration from taking a group of people that are being held in a detention facility in a certain area of Texas. These are the people that were previously boarded on buses that NBC News literally chased on their way up the highway to an airport and back around again. They cannot take those folks, put them on a plane to El Salvador. And the reason they can't do that is because the court wants a lower court to decide two things. How likely are the plaintiffs to succeed in their argument that the Alien Enemies Act is not fairly applied to them? What does the Alien Enemies Act mean, for example, when it talks about a predatory incursion or an invasion or a war? Has Trump fairly applied it to this set of facts? And they want the lower court to decide, are the plaintiffs likely to succeed on that? The second thing they want the appeals court to decide is how much notice these people are entitled to. And the Supreme Court is saying emphatically here, whatever that number is, 24 hours ain't enough. Go back to the drawing board and decide. And the final thing that they're saying, and this is really important, is that this injunction that they're continuing right now is going to last for some time. It's going to last until that lower court, the Fifth Circuit Court of Appeals, not only makes its decision, but until any petition for review by the Supreme Court is disposed of. We're used to thinking about all of these emergency cases that are percolating through the court. But you and I both know, in the ordinary course, it takes a long time for a case to go through the traditional appeals process. So this is a sign to the Trump administration. Not only can't you do this now, but you might be stymied in doing this to this particular group of people for months to come. And you can't go into any other court in the country where you might have detainees and allege that 24 hours notice is going to be enough to give people the due process that the court here, a 7-person majority on this court, is reasserting is imperative to give not only to citizens, not only to undocumented immigrants, but even to alleged members of Tren de Aragua.
Okay, let me ask you 3 questions. 1, does this only protect from deportation to El Salvador the people who were, does this do anything for the people that they already used the Alien Enemies Act to send to this brutal prison in El Salvador?
No. Those people are being, I don't want to say dealt with, but there is a separate court proceeding still in front of James Boasberg, who's the district court judge who originally had Alien Enemies Act proceedings in front of him. And one of the things that is being decided before him is, does he have jurisdiction even over the claims of people who are now in CCOT or other facilities in El Salvador?
But so this was about the Supreme Court telling those, and Von Hilliard, I think, was doing that great reporting, to turn the buses around, that you couldn't send them out. Boasberg also said, turn the planes around.
Boasberg did say turn the planes around, and he was about to engage in some discovery about who was being contemptuous of his order when the Supreme Court vacated that order that he had issued saying turn the planes around. Well, now the plaintiffs have come back before him, people representing those people who are now in El Salvador, and essentially said, okay, the Supreme Court told us that we had to file these cases in the places people were detained. Obviously, we can't do that for people who are in El Salvador already. And we have to file these cases in a particular way. We have to bring them as habeas corpus petitions. So we're going to do that for you now. And Boasberg has said to them, first, I have to figure out whether I have jurisdiction. And what that turns on is, does the United States have what he calls constructive custody over these people in El Salvador? It depends on, is the U.S. sufficiently in control of them, even though, nominally speaking, they're in El Salvador? And he, at the last hearing, quoted back to the government lawyer Trump's interview with our colleague Kristen Welker and a number of other statements from folks in the administration that he said are a good indicator that the United States, despite all of the kabuki theater we've seen in Oval Office press availabilities, that yes, the United States does have constructive custody, but that issue has not yet been decided. Stay tuned for that.
So, Charlie,
what was the specific legal basis for the Supreme Court's April 2025 rulings on deportations under the Alien Enemies Act, and how did the court justify its decision to allow or block these deportations? How did the Supreme Court define reasonable time for detainees to challenge their deportations via habeas corpus? And what practical challenges might arise from this ambiguity? What do you think about this ruling? Comment below. Now back to the video.
So, Charlie, I mean, what we have here is an instance where the Supreme Court is saying some of the same things that protesters at Chuck Grassley's town halls are saying, which is due process. That we, and I know it's a very low bar, but we do still have today a 7-2 ruling that is in the vein of affirming due process rights in this country, even for people here illegally, as Lisa Rubin just said, even for people who are accused but not proven to be members of a gang.
That seems to be a very, very important point. Lisa explained this very, very well. I have a very, very quick question, though. Was it 7-2 or really was it 8-1? Because I'm just looking very, very quickly at it, and I'm not the lawyer here, but it looks like Justice Kavanaugh wrote a concurring opinion, and only Justice Alito wrote a dissent, which would suggest that you have 7 or 8 of the Supreme Court justices that say, wait, we are not prepared to ignore due process, and that this would come down basically a week after Stephen Miller rolls out of the White House and says they are seriously considering suspending habeas corpus. And the court is certainly sending, the majority of the court, sending a very clear message that, no, we are not prepared to ignore due process rights for these migrants. So I think that the number of justices that signed on to this, the speed with which the court acted, really does send a signal that in fact people do care about due process, and that the court is going to draw a red line. They may give Donald Trump in other cases things that he wants, but in this case, they have been relatively consistent, I think, and at least trying to, fire these shots across the bow that, no, sorry, not on our watch. We're not going to be doing this.
Well, Charlie, to answer your question about how the split was, the dissent by Justice Alito is also signed by Justice Thomas. I want to go to your point, though, about Justice Kavanaugh is well taken, because one of the things Justice Kavanaugh does is he would actually go further than the court was. He basically says, look, there's no reason not to engage with the merits right now. The circumstances, I'm going to read from the last paragraph of his concurrence, if you'll forgive me this. The circumstances call for a prompt and final resolution, which likely can be provided only by this court. At this juncture, I would prefer not to remand to the lower court and further put off this court's final resolution of the critical legal issues. We saw shades of that yesterday in the birthright citizenship argument, right? Where you saw folks from Justice Kagan, Justice Jackson essentially saying, why are you before us here on this procedural issue when we could be dealing with the substance?